Good morning, everyone. A happy Friday to you all. My name is Jonathan Waters. I'm a barrister, mediator and arbitrator. And I'm going to be talking to you this morning about the post-pandemic world and the impact on contractual terms and clauses. Next slide, please. So before we start, just to query whether we are in fact in a post-pandemic world. I suspect very much that we're not. We're looking at the possibility of a third wave in the UK, and of course we have had new variants of COVID-19 identified, such as the Delta or the Indian variants. So it seems to me that COVID and its implications on contracting is going to be with us for the foreseeable future. And this, of course, then raises questions as to how contractual risks need to be managed. Next slide, please. What I'm going to talk to you first of all about is some of the contractual disputes that I've come across in the last 15 months. And I've certainly noticed an increase in contractual disputes, in particular in the context of PPE, and PPE is personal protective equipment, and in particular PPE sourced from the Far East. So I'm just going to explain some of the disputes that I've come across, because these disputes have a bearing not just on PPE but on contractual terms and conditions generally. One of the areas I've come across most frequently is the delay in performance or the failure to perform or to deliver. And the question which then arises is, to what extent is the seller liable, and can the seller claim force majeure? And I'm going to talk to you about force majeure separately in a couple of minutes' time. I've also come across disputes where goods have been misdescribed, and that's not always the seller's fault. And I'm just going to give you an example. This is a PPE dispute that I was involved in. A contract was entered into for, quote, surgical masks, unquote. The value of the order was circa $500,000. The purchaser was based in the UK and the seller was based in China. Well, the masks were delivered, but on delivery, it was found that they couldn't be used in the UK because they didn't meet the relevant UK safety standards. The purchaser, who, as I say, was based in the UK, had failed to specify use, and contractually had simply asked for and was supplied with, quote, surgical masks, unquote. So a dispute arose, and it's still ongoing, as to what the meaning of the word surgical mask were in the context of the purchase. In other words, did there have to be a requirement that the surgical masks had to meet a certain standard? And this dispute has arisen quite simply because the parties failed to specify when contracting what the goods were actually going to be used for. And I'll come back to that point in a moment. When a contractor is contracting under UK law, the 1979 Sale of Goods Act will apply. And the Act requires that all goods that are bought or sold in the UK have to be as described, that's section 13 of the Act, and or of satisfactory quality and or reasonably fit for their intended purpose, and that's under section 14. In principle, if the goods do not meet one or more of those criteria, the seller will be in breach of contract. Now, of course, this is the position under UK law, and I'm going to discuss with you another issue which has arisen frequently, and that is which law applies, and I'm going to do that in a couple of minutes' time. But just to go back to the Sale of Goods Act, the Sale of Goods Act implies certain conditions into the contract. In other words, the parties don't necessarily have to agree because the law implies those conditions. And because they are conditions, they become a fundamental or a key term of the contract. And the remedy in English law for a breach of a condition is that the innocent party, quote, is able to terminate the contract and or claim damages. So it's a very important act. So that's the Sale of Goods Act 1979, and I'll come back to that again a little bit later on. If we can just move to the next slide, please. Now, I touched upon the issue of force majeure, and I explained that I've seen an increase in contractual disputes, particularly in the context of a failure to perform or a failure to deliver. And the question which arises is whether or not the failure amounts to an act of force majeure. So what I need to do now is to explain what force majeure is. Well, in very simple terms, force majeure is an event which is outside of the control of the parties, which prevents performance of the contract. Now, if force majeure applies, then it has the effect of releasing the contract, so I beg your pardon, releasing the parties from their contract. In other words, there is no breach of contract. The contract comes to an end due to the fault of neither party. And I think you can probably see from that there is quite a lot of game playing when it comes to force majeure. And force majeure in practice is quite often used as a vehicle to get out of a contract, but in practice it is very difficult. Now, on the assumption that it is English law which governs your contract, more of that in a moment, we need to look at the position of force majeure under English law. But as far as English law is concerned, force majeure is what lawyers call a creature of contract. There will inevitably be a term in the contract dealing with force majeure, and it is for the parties to agree on the meaning of force majeure. In other words, it's entirely contractual. But putting that to one side, it is still difficult to successfully argue force majeure. And you'll see a little box there on the screen about what a claimant must prove, which I'll come back to in a moment. The question which has arisen a lot over the last 15 months is this: is COVID-19 force majeure? Well, the answer depends upon the contract. And as I said, force majeure is a creature of contract. And to claim force majeure arising from COVID, you would need an explicit definition in the contract. Now, that definition could be, for example, a pandemic, or it could potentially fall within another definition, such as an act of God. And the English courts regard an act of God as including a pandemic. So the answer to the question, is COVID-19 force majeure, is a look at it from another point of view. Let's assume that I am the claimant and I'm looking to claim force majeure because I feel that I am unable to perform my contractual obligations. What is it that I have to prove? Well, first of all, I've got to prove that I can't perform because of force majeure. And as I said, it is force majeure as defined by the contract. And in determining whether something falls within the contract, the wording of the contract will be looked at very carefully. The second point is, again, looking by reference to the contract. Does the contract refer to prevention of performance or delay in performance? If, for example, the contract refers to prevention of performance due to force majeure, I, as the claimant, have to show that the force majeure has caused an inability for me to perform my contractual obligations. In addition to that, a further hurdle. English law says, well, okay, fair enough. But the second question that has to be asked is it not possible to perform your contract by other means? If it is still possible to perform your contract by other means, then it's unlikely that you're going to be able to claim force majeure. And something else to bear in mind, most contracts will state if a party wishes to claim force majeure, they'll have to serve notice on their counterparty, and that requires consideration of the notices clause within the contract. Quite a complicated area of the law, but in very simple terms, if the contract requires you to give notice in a particular form, for example, by email, served upon a particular address, then you've got to do it. If you fail to give notice in accordance with the contract, then the law could well take the view you haven't given notice, with the consequence that you cannot claim force majeure as defined in the contract. So in very simple terms, if you're in a situation where you're looking to claim force majeure, check the contract. Does the contract specifically define the event in question? Does the contract focus on prevention or delay? Has the force majeure caused the failure to perform? Is it possible to perform by other means? And have you complied with the notices clause? So there are a number of hurdles that have to be overcome before force majeure can be successfully claimed. I put on the slide what isn't force majeure, and what isn't force majeure, and this is based upon case law, is that if a party is being put to additional expense but can still perform, that's not force majeure. Similarly, delay when the contract refers to prevention is not force majeure, and neither is inconvenience. So you've got to look at the contract, and on the assumption that the contract requires the force majeure to prevent performance, you've got to be able to prove that it has prevented. And as I say, this is an area where we see a lot of game playing between the parties, and it is quite often used as a device for one party to try and wriggle out of the contract by claiming force majeure in circumstances where there is no force majeure. And beware, if you get it wrong and you claim force majeure and it's not force majeure, then you are in breach of contract and your counterparty can bring action against you. Thank you. Next slide, please. Now, this is a particular area that I've come across a lot in the last 15 months. Whose law is it anyway? In other words, in the event of a dispute arising, which law will apply? Now, best advice here is in your commodity contract, you need to define which law will apply to the contract and which courts will have jurisdiction in the event of a dispute arising. And normally this is dealt with by what lawyers call a domicile clause within the contract. And as I say, the domicile clause will identify the law which applies and identify which courts have jurisdiction. It's a clause which, in my experience, is frequently overlooked, a bit like the notices clause, and it only becomes relevant and parties only tend to think about it when a dispute arises. But it is very important that you consider this as part of your due diligence and pre-contractual risk assessment. Let me just give you an example of a case that I'm currently involved in, which demonstrates how complicated this can become. So this is another contractual dispute relating to the sale of PPE, but frankly, the principle that I'm going to discuss can apply to any form of commodity contract. In this particular case, a contract was entered into by purchase order. The buyer failed to incorporate their standard terms of business. They simply contracted, as I say, on the basis of a purchase order. The purchaser was based in the UK. The supplier was based in Spain. However, the supplier was acting as an agent for a Chinese company. A contractual dispute then arose as to the cost of the gloves. And what the supplier sought to do was to increase the contractual price in breach of contract, according to the purchaser, to reflect the additional cost that they've incurred due to a number of factors. The first was as a consequence of the blockage in the Suez Canal for 6 days this March, which delayed transport. The second was the COVID-19 situation in China and in the UK. And the third was the lack of containers to ship the goods on the market. So in other words, the Chinese company said to the supplier, the price has gone up, and the price had gone up quite significantly, about 25%. The supplier then said to the purchaser, the price has gone up, you need to pay the additional price. The purchaser in the UK said no and cancelled the contract as a consequence and sought to return their deposit. Now that deposit was quite significant, it was £250,000. So we have a contractual dispute. But as a fundamental point, the issue is this: whose law actually applies? Is it English law? Is it Spanish law? Is it Chinese law? Now, I'm not going to go into any more detail, but this is a live dispute, but it just illustrates when the parties haven't agreed on domicile, in other words, which law and which courts will have jurisdiction. It illustrates the complexity of not thinking about this, because we have a situation here where, frankly, it is unclear as to whether English law applies with the consequence that the English courts will have jurisdiction, or Spanish law and Spanish courts, or Chinese law and Chinese courts. And that is a problem that could quite easily have been prevented as part of a contractual due diligence process. So whose law is it is a really important point that parties should give very careful consideration to prior to contracting. Next slide, please. So what I'm going to talk about briefly is some trends. What is actually happening in practice? And this is all based upon my experience. Well, firstly, what I've seen is force majeure clauses are now gaining much more momentum. Force majeure clauses historically are clauses that have been tucked away in a contract, very often in standard terms and conditions, and no one's paid much attention to them. But they're now coming very much to the fore. And companies who have had force majeure clauses in place for some time are now taking the opportunity to revise and to renegotiate those clauses with their counterparties. Similarly, what some contractors are doing is that they're moving away from force majeure clauses and introducing explicit COVID-19 clauses to deal with the effects of COVID. For example, cancellation, delay, disruption. And they're looking at that as an alternative to force majeure. Actually, we see this quite often in the hospitality industry, where in addition to force majeure, the hospitality industry in particular has introduced COVID explicit clauses within their contracts. What I've also seen is what I call cautious contracting. In other words, parties are now thinking about the risk of delay, about cancellation, and trying to reflect that within their contracts, for example, by incorporating an extension of delivery or an extension of shipment provision within the contract, which effectively allows them to extend the delivery period by a contractually stipulated amount of time in the event of delay caused by COVID. I think it's also fair to say that there has been a much greater awareness of risk management and contractual due diligence as a consequence of COVID. What some other contractors are doing, they're looking at what lawyers call a material adverse change clause as an alternative to, or indeed in addition to, force majeure or an express COVID-19 clause. And in very simple terms, a material adverse change clause is a clause, a contractual clause, which gives a party the right to terminate if certain defined events occur which are detrimental to that company's interests. Now, these clauses are often very widely defined within the contract, and quite often they focus on the counterparty's financial position. So in other words, if the counterparty's financial position has significantly deteriorated, then that might trigger the material adverse change clause, giving the other party the right to terminate. What I've also seen is an increased awareness of alternative dispute resolution, mediation, arbitration, and expert determination. And one of the reasons for that is that the courts, particularly in the UK, have been subject to quite significant delays as a consequence of COVID. Court workload has backed up. And what that has resulted in practice, in particular when it comes to arbitration and mediation, is the increased use of virtual hearings where parties can participate via, for example, Zoom or Teams. Next slide, please. The next two slides are really about avoiding risk, and what it seems to me is that there needs to be a greater emphasis on what I call pre-contractual due diligence, and in addition to that, knowing your contract. Next slide, please. Sorry, just go back one. Thank you. What I find is that parties very rarely read their contracts. English law, assuming that your contract, of course, is subject to English law, makes a number of assumptions. The assumptions include that once agreed, you are bound by the contract. English law assumes that you have read the contract and have understood the contract and are therefore happy to be bound by that contract. If the contract contains wording that is ambiguous, then you've got to be trying to resolve that prior to contracting, because ambiguity, in my experience, causes a lot of contractual disputes. In fact, I would say that is one of the main causes of contractual disputes. What does a particular clause mean? Party A says it means X, Party B says it means Y, and it's then for a court or an arbitrator to determine the meaning. And you can avoid all of this by having clarity in your contract before contracting. Similarly, know your counterparty, carry out proper due diligence, look at issues such as payment. If, for example, you are contracting with an unknown party, look at deposits, look at parent company guarantees, look at bank guarantees, look at having the money paid into escrow, and look at problems, try and foresee problems that might arise. For example, deal with the possibility of delay within the contract. Look at having a liquidated damages clause which predetermines the amount or the basis upon which damages may be calculated in the event of a breach. My final slide before we look at some questions. Next slide, please. Is avoiding fraud. And I've been asked the question, can improved contract drafting protect against fraud? To be frank, my opinion is no. It's very unlikely, because fraud is fraud, and with fraud, contractual provisions will be disregarded. So it comes back to this basic principle, I think, about contractual due diligence, carrying out the necessary checks into your counterparty before you proceed with the contract. Look at their financial standing, credit checks, bank checks, take references, look at guarantees, look at litigation checks with certain contractors within certain sectors. For example, in soft commodities, trade associations maintain defaulters lists, which is a list of companies who have defaulted on arbitrations. GAFTA, for example, maintains such a list, and it enables GAFTA members, for example, to look at the list and look at the companies who have defaulted on GAFTA awards of arbitration. And that in turn begs the question, if the company or prospective counterparty appears on the list, do you really want to enter into a contract with them? Now, as you can imagine, this is a huge subject, and I can only really touch upon some of the key issues and trends. So what I'd like to do now is really to open the floor, and I believe we've got about 5 minutes left to consider whether anyone has any questions. So it's really over to you. Are there any questions, please?
We have had some questions in, yes.
Okay.
So the first one, Jonathan, do you have insights around the Suez Canal blockage's legal impact?
Yep. Just go back a second. The Suez Canal blockage occurred in March of this year, and it lasted for approximately 6 days, and it did have a significant impact on shipping and shipping container contracts in particular, which were using Suez. The question, Does it have an impact on the contract? Will depend on the contract, first of all. For example, an impact upon delivery dates. And the consequences will again depend on the contract. Does the contract contain a mechanism, for example, to enable a party to extend delivery? Or is there a clause dealing with the question of delay and the consequential assessment of any loss and damages caused by delay? So the answer to the question is it is purely a matter of contract, hence the importance of making sure that you get the contract right in the first place and understanding precisely what it is that you're contracting to. Any more questions?
I've got a couple more, if that's okay.
Okay, yeah, no problem.
How difficult is it to prove force majeure?
Okay. I think everyone could probably appreciate, based upon my earlier slide, that it is actually very difficult. Remember all of those steps that you have to walk over. Is it force majeure as defined by the contract? What is the consequence of force majeure? Has it prevented performance? Is it possible to perform by other means? Has the notices clause been set aside, for example? So in practice, whilst I see a fair amount of force majeure claims, particularly over the last 15 months, very few actually succeed, but it doesn't stop parties, as I mentioned earlier, game playing. So in circumstances, for example, where the supplier no longer wishes to perform, for example, the market may have changed and the contract no longer becomes profitable, then that party may look at alternatives to try and argue force majeure. But that's game playing, and it is very difficult indeed to prove.
Interesting. Okay.
Any more questions, Megan?
Yes. Would you advise arbitration over litigation?
Well, I'm going to be slightly biased because I am an arbitrator and I'm also a mediator. Putting that to one side, I think in the current climate, yes, I would, for the simple reasons as follows. Arbitration tends to be far quicker. Courts at the moment are still subject to delays because of COVID. Arbitration is also, when compared with litigation, far cheaper. And in addition, arbitration enables an independent third party or third parties to make a determination on a contractual issue in which they have specialist knowledge. Courts don't necessarily have the specialist knowledge. So just briefly, to take an example, with GAFTA contracts contain an arbitration clause. The parties sign up to GAFTA arbitration, and the arbitrators that GAFTA use, and we have over 80, are all specialists within that particular sector. And you don't get that degree of specialism when you go to court. So it's something to give consideration to. And yes, in answer to your question, I would certainly recommend arbitration over litigation, i.e. going to court.
Thank you. We've just had another one come through. So in today's COVID context, even if specific clauses on COVID impact are included in the contract, would additional force majeure clause cover other factors not covered?
Okay, well, I think we have to go back to basics. And if you already have a force majeure clause, I think you should be asking yourself the question, how specific is it? Is it going to include the risks that I'm particularly concerned about? If it doesn't, you need to be looking at amending your force majeure clause. And quite separately from that, if you have a particular concern arising from force majeure, let's take, for example, delay, then query whether you want to go even further within the contract and include an explicit clause dealing with the risk of COVID-19 delay, or even go further than that and look at the possibility of having a material adverse change clause. So it's all about looking at the contractual provisions and asking yourself a very simple question. If this all goes horribly wrong, am I going to be exposed, whether that exposure is financial or legal? But does the contract give me the protection that I require? And if you're in any doubt, then my advice is to take some independent legal advice and have the contract amended to reflect the particular risk that you're concerned about. Do we have any more questions?
I think that is it. I'll just give everyone a couple more seconds in case somebody's finishing off typing one.
Okay. I'm just looking at my screen as well. We don't appear to have any further questions, and I'm very conscious that I'm getting close to the end of my session. So unless there are any further questions, I'd just like to conclude and say thank you very much to ComRisk for inviting me to present. I've really enjoyed it. This is the third time I've presented. I hope that those of you who are listening have found this interesting. I believe that a copy of my slides will be available to those who require it. And just remains for me to say enjoy the rest of your Friday, and thank you very much for listening.